May 2, 2023 Unit 6 Real Estate Contracts, Advance Costs. Advance Fee Addendum. Burden of Proof. Buyer Listing. Cooperating Broker Fee Agreements. Due Diligence. Exclusive Agency Listing. Exclusive Authorization and Right to Sell Listing. Good Faith. Hold Harmless Clauses. Interim Occupancy Agreement. Loan Broker Listing. No Deal and No Commission. Open Listings. Privity of Contract. Procuring Cause. Safety Clause. 1. What are advance costs in real estate? A. Fees paid in advance to secure property. B. Costs associated with selling a property. C. Expenses paid by a buyer in advance of closing. C. Expenses paid by a buyer in advance of closing. An advance fee addendum is an agreement specifying services for which an agent or broker will be compensated, including a provision for payment of an advance fee. 2. What is the burden of proof in a real estate dispute? A. The obligation to prove that a contract is valid. B. The obligation to prove that a property has been properly maintained. C. The obligation to prove that one party is at fault in a dispute. C. The obligation to prove that one party is at fault in a dispute. 3. A buyer's listing can refer to a marketing approach for real estate agents to generate leads by creating and marketing buyer listings. It can also refer to a situation where a real estate agent tries to convince a buyer to work with them in buying a home, regardless of whether it is the buyer's home or not. 4. A cooperating broker fee agreement is a contract frequently used in the real estate industry that outlines the commission split between the listing broker and the cooperating broker. 1. What is due diligence in real estate? A. The process of researching a property before buying or selling it. B. The process of negotiating the terms and conditions of a real estate transaction. C. The process of obtaining financing for a real estate transaction. A. The process of researching a property before buying or selling it. 1. What is an exclusive agency listing in real estate? A. A type of listing agreement where the seller is only allowed to work with one real estate agent. B. A type of listing agreement where the seller can work with multiple real estate agents, but only the agent who brings in the buyer will receive a commission. C. A type of listing agreement where the seller can work with multiple real estate agents, and the commission will be split among them. B. A type of listing agreement where the seller can work with multiple real estate agents, but only the agent who brings in the buyer will receive a commission. A. The legal obligation to act honestly and fairly in all real estate transactions. 1. What is an exclusive authorization and right to sell listing in real estate? A. A type of listing agreement where the seller is only allowed to work with one real estate agent. B. A type of listing agreement where the seller can work with multiple real estate agents, but only the agent who brings in the buyer will receive a commission. C. A type of listing agreement where the seller agrees to pay a commission to the real estate agent, regardless of who brings in the buyer. C. A type of listing agreement where the seller agrees to pay a commission to the real estate agent, regardless of who brings in the buyer. 2. What is a right to sell listing in real estate? A. A type of listing agreement where the seller is only allowed to work with one real estate agent. B. A type of listing agreement where the seller can work with multiple real estate agents, but only the agent who brings in the buyer will receive a commission. C. A type of listing agreement where the seller agrees to pay a commission to the real estate agent, regardless of who brings in the buyer. C. A type of listing agreement where the seller agrees to pay a commission to the real estate agent, regardless of who brings in the buyer. A. Provisions in a real estate contract that limit the liability of one party for certain actions or events. 2. Which of the following types of listing agreements provides the most incentive for a real estate agent to market a property? A. Exclusive agency listing. B. Exclusive authorization and right to sell listing. C. Right to sell listing. B. Exclusive authorization and right to sell listing. 1. What is good faith in real estate? A. The legal obligation to act honestly and fairly in all real estate transactions. B. The legal obligation to provide accurate information about a property to prospective buyers. C. The legal obligation to negotiate in good faith with all parties involved in a real estate transaction. 2. What are hold harmless clauses in real estate? A. Provisions in a real estate contract that limit the liability of one party for certain actions or events. B. Provisions in a real estate contract that require the buyer to purchase additional insurance. C. Provisions in a real estate contract that allow the seller to back out of the agreement at any time. 3. What is interim occupancy in real estate? A. The period of time between when the buyer takes possession of the property and when the sale is finalized. B. The period of time between when the seller accepts an offer and when the buyer takes possession of the property. C. The period of time between when the buyer applies for a mortgage and when the loan is approved. B. The period of time between when the seller accepts an offer and when the buyer takes possession of the property. 4. What is an interim occupancy agreement in real estate? A. A legal document that outlines the terms and conditions of the period of time between when the buyer takes possession of the property and when the sale is finalized. B. A legal document that outlines the terms and conditions of the period of time between when the seller accepts an offer and when the buyer takes possession of the property. C. A legal document that outlines the terms and conditions of the period of time between when the buyer applies for a mortgage and when the loan is approved. A. A legal document that outlines the terms and conditions of the period of time between when the buyer takes possession of the property and when the sale is finalized. 1. What is a loan broker listing in real estate? A. A type of listing agreement where the seller is required to use a specific loan broker to finance the sale. B. A type of listing agreement where the real estate agent is also licensed as a loan broker. C. A type of listing agreement where the real estate agent agrees to assist the seller in finding a loan broker. B. A type of listing agreement where the real estate agent is also licensed as a loan broker. 2. What is no deal no commission in real estate? A. A type of listing agreement where the real estate agent is only paid a commission if they successfully sell the property. B. A type of listing agreement where the seller agrees to pay the real estate agent a commission regardless of whether or not the property is sold. C. A type of listing agreement where the real estate agent is paid a commission upfront regardless of whether or not the property is sold. A. A type of listing agreement where the real estate agent is only paid a commission if they successfully sell the property. 3. What are open listings in real estate? A. Listing agreements where the seller agrees to work exclusively with one real estate agent. B. Listing agreements where the seller can work with multiple real estate agents, but only the agent who brings in the buyer will receive a commission. C. Listing agreements where the seller can work with multiple real estate agents, and the commission will be split among them. B. Listing agreements where the seller can work with multiple real estate agents, but only the agent who brings in the buyer will receive a commission. 4. Which type of listing agreement is most commonly associated with no deal no commission? A. Loan broker listing. B. Open listing. C. Exclusive agency listing. B. Open listing. 1. What is privity of contract in real estate? A. The legal relationship between the buyer and seller in a real estate transaction. B. The legal relationship between the real estate agent and their client in a real estate transaction. C. The legal relationship between the real estate agent and the cooperating broker in a real estate transaction. A. The legal relationship between the buyer and seller in a real estate transaction. 2. What is procuring cause in real estate? A. The real estate agent who initiates contact with the buyer or seller and begins the process of a transaction. B. The legal doctrine that establishes the real estate agent who brought about the sale as the one entitled to the commission. C. The requirement that the real estate agent must provide proof of their actions that resulted in the sale. B. The legal doctrine that establishes the real estate agent who brought about the sale as the one entitled to the commission. 3. What is a safety clause in real estate? A. A provision in a listing agreement that requires the seller to notify the real estate agent before selling the property to a buyer introduced by the agent. B. A provision in a real estate contract that requires the buyer to provide proof of their ability to finance the purchase. C. A provision in a real estate contract that requires the seller to disclose any known defects or issues with the property. A. A provision in a listing agreement that requires the seller to notify the real estate agent before selling the property to a buyer introduced by the agent. May 2, 2023 Unit 6 Review Real Estate Contracts. A listing is an agency contract whereby a principal, usually the property owner, appoints an agent, a real estate broker, to perform some task. Customarily, The principal gives the agent a listing to procure a buyer or a lessee for specified property. Listings also can be created for the purpose of locating property for a buyer or obtaining financing. A listing can also be for a loan modification. An agent who is to procure a buyer generally is not given the power to obligate the principal contractually. The agent solicits offers, the principal accepts or rejects them. A buyer's agent locates property for the buyer's consideration. The buyer makes any purchase decision. To be enforceable, listing agreements for real estate must be in writing. Because listings are contracts, they require all the elements of a valid contract to be enforceable: mutual consent, consideration, legal purpose, and competent parties. Listings usually authorize an agent to place a for sale sign on the property. Without such authorization, the agent does not have the right to place a sign. Unless the listing authorizes the agent to accept a deposit, the agent will have to take deposits as the agent of the buyer. Hold harmless clauses customarily are included in listings. The owner agrees to hold the agent harmless and indemnify the agent for losses in the event the owner fails to provide a disclosure or fails to provide correct information. Unless a listing authorizes an agent to employ subagents, the agent has no authority to do so. An agency is a personal relationship that requires consent, and the principal is responsible for the acts of the agent within the scope of the agency. The agent therefore has no authority to expand the liability of the principal to acts of subagents without the express authority of the principal. The amount or rate of real estate commissions is not fixed by law. They are set by each broker individually and may be negotiable between seller and broker. The commission normally is paid upon close of escrow, which could be sometime after the commission is earned. Exclusive listings. Most listings are exclusive listings, in which the owner makes the agent the owner's exclusive agent to procure a buyer and agrees to pay a commission should the agent succeed. The agent promises to use due diligence in procuring a buyer. As mentioned in Unit 5, this mutual exchange of promises makes exclusive listings bilateral contracts. Exclusive listings must be signed by the owner. Agents are required to give a copy of an exclusive listing to the owners at the time they sign. Failure to do so does not void the listing, but it does subject the agent to disciplinary action. Exclusive listings must have a definite termination date. Exclusive listings generally provide that if the seller cancels the listing, leases, or rents the property without the approval of the agent, or otherwise adversely affects its marketability, the agent is entitled to a commission. Exclusive authorization and right to sell listing. With an exclusive authorization and right to sell listing, the owner agrees to pay a commission to an agent if the agent, any other agent, or the owner procures a buyer in accordance with the price and terms of the listing, or for any other price or terms that the owner accepts. Exclusive right to sell listings frequently contain a safety clause. This clause customarily provides that the owner is obligated to pay a commission if a sale is made within a stated period after expiration of the listing to any person the agent negotiated with and whose name was furnished in writing to the owner within 3 days after the expiration of the listing. Exclusive agency listing. Under an exclusive agency listing, the named broker is the exclusive agent for the owner, and if the listing broker or any other agent procures a purchaser in accordance with the terms of the listing, or any other price and terms the owner might agree to, the agent has earned a commission. The owner can, however, sell the property without the assistance of the agent and without any obligation to pay a commission. Open listings are non-exclusive listings. They may be offered to one or more brokers. The broker who earns the commission is the first agent to bring the owner an offer that meets the terms of the listing or that the owner accepts. A sale under one open listing automatically cancels all other open listings. The principal has no duty to notify the agents under other open listings of the sale. The open listing is really a unilateral contract. Unlike exclusive listings, open listings need not have a definite termination date. The agent who is the procuring cause of a sale is that agent who initiated an uninterrupted series of events that led to the sale. A buyer listing, like a listing from owners, can be exclusive. The broker has the sole right to locate property for the buyers. In a buyer exclusive agency listing, the buyers can locate property for themselves, but the broker is the exclusive agent. Like a seller's listing, a buyer's listing, to be enforceable, must be in writing and signed to satisfy the statute of frauds. An oral agreement by a buyer to pay a commission is unenforceable. Net listings refer to the commission payment only and provide that all money received over a stated or net amount will be the agent's commission. The agent must disclose the amount of the net commission before or at the time the principal commits to the transaction. The advance fee addendum usually sets forth specific activities that the agent is to be compensated for, as well as an hourly rate, or set rate, for the compensation. Advance costs differ from advance fees in that they are paid to the agent to cover cash outlays in carrying out the agency. Monies collected to cover advance costs must be treated as trust money and must be placed in the broker's trust account. The trust fund remains the property of the principal until disbursed by the agent for the principal. Additions to the purchase agreement: contingencies. Offers to purchase often are contingent on something happening, such as receiving an appraisal for a stated amount or more, obtaining a loan to stated specifications, or the sale or purchase of another property. The most common contingency is an offer contingent on financing. As-is clause. An as-is clause in a purchase agreement can lead to problems. As discussed in Unit 3, as-is generally applies only to patent defects, which are obvious defects, and not to latent or hidden defects known by the seller and/or agent. Mortgage loan disclosure statement: before a borrower is obligated to complete a non-federally related loan agreement arranged by a real estate broker, the borrower must be given and must sign a mortgage loan disclosure statement setting forth all costs and fees, payments, liens, etc. Retention of records: a real estate broker must retain, for 3 years, copies of all listings, deposits, receipts, canceled checks, trust records, and other documents executed by the broker or obtained in connection with any transaction for which a real estate license is required. Advance fee addendum to listing: this agreement sets forth activities for which the agent is to be compensated, as well as the fee to be paid in advance. Advance costs addendum: this addendum covers costs to be advanced to cover expected broker outlays. Listing modification: this agreement allows changes to the listing without an entire new agreement. Loan broker listing agreement: this listing gives the loan broker the right to obtain a loan for a prospective borrower. Seller's net: this is a statement from the agent that shows what the owner will have after all costs, payments, and expenses. Unit 6 Real Estate Contracts. Unit Quiz 1: which phrase best describes an owner's oral agreement to pay a real estate sales commission? C. Unenforceable. 2. A broker brought an offer to an owner. While the broker did not have a listing, the offer provided for a commission. The owner crossed out the provision for a commission above the signature block and signed the acceptance. Which is true regarding the broker's rights? D. There was no listing, so no commission need be paid. 3. A valid listing agreement must contain which stipulation? C. Specific reference to the subject matter of the listing. 4. The effect of a hold harmless clause is that it c. means the owner agrees to indemnify the agent for losses suffered because of the owner's failure to disclose or the owner's incorrect disclosure. 5. An exclusive right to sell listing provides for 20% down and owner financing at 13% interest. The owner received a full price cash offer that he does not wish to accept, which is true regarding the owner's rights. C. He may reject the offer without obligation regarding commission. 6. After signing an exclusive right to sell listing, an owner refuses to accept an offer that conforms exactly to the terms of the listing. In this case, specific performance can be obtained by A. the broker, B. the offeror, C. either of these, D. neither of these. Answer D. No contract with buyer and agents. 7. The rate of commission for the sale of real property is set by D. agreement between the parties. 8. A commission is ordinarily earned by a broker when B. the broker procures a ready, willing, and able buyer. 9. A broker's promise to use diligence makes a listing a bilateral contract. 10. On an exclusive listing of a single-family home, a broker can be disciplined for failure to a. include a definite termination date. B. Indicate that the commission is negotiable. C. Give a copy to the owner. D. Any of these. Answer is D. 11. The exclusive listing that broker Jones had on the Adams farm expired at noon on December 15. At 1 p.m. on December 15, Adams gave broker Riley an exclusive listing on the farm. At 2:30 p.m. on December 15, broker Jones procured a buyer at the price and terms of the listing. Who is legally entitled to the commission? B. Broker Riley, the broker with the listing. 12. Which provision would least likely be found in a real estate purchase contract? A. Safety clause, found in a listing. 13. A termination date is required for all contracts below except A. An open listing. B. An exclusive agency listing. C. An exclusive right to sell listing. D. An option, answer except A. An open listing. 14. To be the procuring cause of a sale, the broker must have C. Initiated an uninterrupted chain of events that led to the sale. 15. Procuring cause is of greatest significance in C. Open listings. 16. To collect a commission for a sale on an exclusive right to sell listing, the broker must prove all of the following except A. That there was a valid listing. B. That the sale took place during the listing, an extension of it, or its safety period. C. That the broker was licensed at the time the commission was earned. D. That the broker was the procuring cause of the sale. Answer is except D. That the broker was the procuring cause of the sale. 17. When a listing includes a purchase right and the broker informs the owner that the broker will buy the property, the broker must A. Disclose all known facts to the seller. B. Present any offers received. C. Obtain the seller's written consent to exercise the option. D. Do all of these. Answer D. 18. An oral agreement most likely to be enforceable would be B. An agreement between brokers to split a commission. 19. A listing broker refuses to split a commission with a cooperating broker after agreeing orally to do so. To collect, the cooperating broker would likely C. Start legal action against the other broker. 20. Liquidated damages can exceed 3% of the sales price when the subject property is A. 5 residential units. B. Residential property that the buyer do not intend to occupy. C. A commercial building. D. Any of these. Answer D. 21. An offer to purchase stated that it would remain open for 48 hours. Which statement is true regarding this offer? C. This offer can be revoked by the offeror before the expiration of 48 hours without penalty. 22. A real estate purchase offer fails to specify a time for acceptance. The offer B. Can be accepted within a reasonable period of time. 23. Which statement is true about contingencies in purchase offers? B. The person benefiting by the contingency can waive it. 24. A contract for the sale of a residence stated as is. Which statement is true relating to this provision? B. It applies to visible conditions only. 25. As is would most likely protect a seller from hidden defects when the sale is B. Of a commercial property.